Hello students, welcome to Satva Academy. Here I will be discussing another chapter from the JIGL subject, that is law of torts. Let us see the important topics of the law of torts. Here on screen you can find the important topics and you can expect 6 to 8 marks from these topics, and this will be repeated topics in all the exams of CS executive. Let us see the question from injuria sine damnum versus damnum sine injuria. Now read the question. See the question here. Mr. Ravi, an independent local travel agent, has operated successfully in a neighborhood for 15 years. Due to his good reputation, he enjoys significant market share. Recently, a large online travel company, that is Tripster Limited, established a branch in the same locality. Clear? Then Tripster Limited offers substantially lower price for tickets and hotel bookings. Now that is the benefits given by the newly established branch of the Tripster Limited. Okay. As a result, many of the Ravi's long-term customers switch to Tripster Limited, leading to a significant drop in Mr. Ravi's income and profits. Now Mr. Ravi wants to sue Tripster Limited for causing him financial losses. Now here, because of the operation of the Tripster Limited, Ravi faced a huge loss in his business. Now he wants to claim that compensation against Tripster Limited. Being a legal advisor, you have to advise Mr. Ravi in this case. Okay. See, now you have to analyze the situation based on the legal maxim damnum sine injuria and determine whether Ravi has a valid cause of action against the Tripster Limited. Okay, let's see the applicable provision for this question. See, now you have to apply the damnum sine injuria concept to this scenario. Okay, let's see what damnum sine injuria says. Here, according to that provision, damage without injury. See, here the provision of the damnum sine injuria is, the meaning of that maxim is damage without injury. So here injury is nothing but the violation of your legal right. So that one you are already read in your concepts. Okay. It signifies that where the person suffers actual monetary loss or physical damage, but there is no infringement of any legal right belonging to them. Now, if there is no violation of a legal right, then no suit for the compensation can be maintained. So, this is the rule according to the damnum sine injuria. Okay. Now, there is also a case for the same, that is Gloucester Grammar School case. In that case also, that principle says that economic harm resulting from lawful competition does not constitute a legal wrong in a tort of law. That means when you are carrying a business and if your rival comes to your places and he takes over the market share, and if because of that act if you met with the loss, then for that loss you don't have any compensation, because that person also have the legal right to carry his business and he can legally carry the business and he can compete with your business. So that in such a cases you can't claim the compensation against your rivals. If he creates any barrier to your trade, then you can go for claiming the compensation, because that violates the legal right, but not when he is carrying the business legally. Okay, let's analyze the question according to the provisions of this maxim. Okay, see here Mr. Ravi has indeed suffered financial harm due to the competition from the Tripster Limited. So this is the fact. Because of the Tripster Limited only Ravi faced the huge loss, and here Tripster Limited has acted lawfully in opening the new business and offering competitive prices, and he didn't that company did not create any barrier to Ravi's business. They just extended their business and started a branch office in that locality, and customer, because of the competitive prices, Ravi's customer switched to Tripster Limited. Now that is not the wrong actually according to the law. Now competition in business, even if harms a competitor, does not infringe upon the legal right of that competitor. Here in any situation company did not violate the rights of the Ravi. Now okay, therefore there is no violation of the Mr. Ravi's legal right, that is injuria, to carry out his business. Now While applying all the legal provision, you can clearly understood that there is no violation of the legal right of Mr. Ravi. So that the conclusion is here, Ravi cannot get the compensation even if he files the case against Tripstar Limited. Okay, let's see the conclusion here. Now, Mr. Ravi does not have a valid cause of action here. Means there is no legal violation, legal right violation by the Tripstar Limited, so that here Ravi will not get any compensation according to the rule of damnum sine injuria. So this is what the concept of the damnum sine injuria, where there is no legal right violation and there is no damage. Means there is no compensation by the court of law. If there is a legal right and there is no legal financial damage, still you can claim the compensation. That is vice versa in case of injuria sine damnum. So injuria sine damnum means even though there is no financial harm or else physical damage, still you can claim the compensation in case where your legal right has been violated by the other party. So that is the concept of injuria sine damnum. So you can concentrate on that topic also. You may get the question out of that topic. Okay, let's continue with the next topic. So that is from strict liability and its exceptions. So that's the case discussed in Rayland and Fletcher. Okay, let's see the question here. Read the question first. See the scenario of the question here. Garg Cement Industry, that is GCI, operates a large factory. As a part of its operation, it maintains a massive artificial water reservoir on its premises. For a cement factory, water is the important element, so that they have constructed an artificial water reservoir for its operation. Okay. Now, the reservoir's construction was approved by the regulatory authorities. That means once you get the approval from the concerned authorities, that will be the valid project. Then designed to hold sufficient water for the factory's operation and prevents localized flooding during the monsoon seasons. It took all the precautions. Okay. During an unusual severe earthquake, it is a geological event recorded to be a 1 in 100 years occurrence. Now there is a earthquake in that area. Now the reservoir wall suffered significant crack and collapsed. The water flooded Mr. Bassin's adjacent farmland and destroying his crops worth rupees 5 lakh rupees. Because of this act, here Mr. Bassin faced a huge loss, that is 5 lakh rupees from his crops. Okay. Now, what is the question? Can Mr. Bassin hold GCI strictly liable for the damage? Now you have to advise the Mr. Bassin for claiming the compensation, whether compensation is available in this case or not. Now for that you have to apply the legal provisions given in the law. Okay, let's see the legal provision. First one, according to the rule of Rayland and Fletcher's case. So here that says that a person who for their own purpose brings on their land and collects and keeps there anything likely to do mischiefs, and if it escapes must keep it in at their peril, and if they do not do so, then they have to pay the compensation. For example, assume if you keep any dangerous or else hazard goods in your premises, and if it escapes and causes damage to other party, in that case the person himself is liable to pay the compensation. And if it is an artificial thing, then even there is an exception for this rule. In case of non-natural use of land, dangerous things brought onto land, and if it escapes and it results in the damage, in all these cases that concerned person should pay the compensation. And there are some defense for this rule also. So the defense or else exception is an act of God. In case of any natural phenomena or else act of God, like natural disasters like these, flood or else earthquake, in that cases there is an exception. The concerned person need not to pay the compensation. So here also in this case, let's see the questions fact. So now we have to analyze the facts with the legal provisions. Now see here, GCI's liability can be exempted by applying the defense, that is act of God. Here the earthquake happened once in 100 years. So that was a massive earthquake, and even the company did not expected that, and companies has no reason to believe that earthquake may happen during that period. So now in this case, earthquake described as once in a 100 years event that qualifies as an extraordinary natural event, and that was not foreseeable by the reason of a human prudence, and for which the factory could not be held responsible for guarding against the total impact. Now this act was a natural phenomenon. For that act, company is not liable, so that in this case company is exempted to pay the compensation. That is the conclusion to be given in your answer. So let's see the conclusion here. See, this is the conclusion to be given in this question. So here Mr. Bassin is not getting the compensation because here he cannot apply the strict liability on GCI company, because what strict liability says, even though you don't commit the wrong, sometimes you have to pay the compensation when your company's worker or else staffs commits any wrong, and because of that wrong, if a third party faces any damages, in such a cases employer is liable even though he don't commits any wrong. Because of the act of his employees, he should pay the compensation. In this case company is the employer, so that company should pay the compensation if the strict liability is applicable. But the thing is, here the act is because of the natural phenomena or else act of God. So now here in this case we can apply the exception, that is act of God. By applying the exception, here company need not to pay the compensation to the other party. So that is the conclusion to be given in your answer. Okay, we'll move to next topic, that is corporate and vicarious liability for the torts. Here vicarious liability means for the wrong committed by the other party, you are paying the compensation. That is the concept of the vicarious liability. That is in case of employer and employee, principal and agent. So this is the concept where if other party commits any wrong, then the employer or else principal is liable to pay the compensation. Okay, let's see the question here. Ravi, an employee of a SpeedX Delivery Services Limited, was delivering the packages in a hurry. While reversing the delivery van on the narrow road, he negligently struck Mr. Kishore, causing personal injury to him. Now Mr. Kishore wants to file a lawsuit to claim compensation. Now because of this damage, Kishore wants the compensation and he wants to file a case against some person. Here the company argues that Ravi's act was outside the terms of his contract and he should be sued personally and not the company. So here you have to give the advice to Mr. Kishore, to whom against the Mr. Ravi can claim the compensation. The question is SpeedX Delivery Services Limited liable for the actions of its employee Ravi? Discuss the principle of vicarious liability in this context. Let's see the legal provisions for this scenario. Okay, see here you have to apply the legal provision of vicarious liability. So that says that general principle where one person held responsible for the tortious act, here tortious act means any civil wrong of another. Clear? Here one person is held responsible for the tortious acts of another person. A key application of his application is the employer and employee relationship. As I told in the beginning of this question, here when employee commits any wrong, then employer is responsible to pay the compensation. That is master and servant relationship. That is a legal relationship between employer and employee. Now employer is liable for the torts committed by the employee if the employee acted in the course of employment. So when an employer should pay the compensation, only in those cases where employee is doing the act of the employer or else in the course of the business. If it is comes under the custom of a business activities, then employer is liable to pay the wrong committed by the employee. Now any party suffers because of the act of employee, and if that act is during the course of the business, then here employer should pay the compensation to third party, that is the person one who faced the loss or else one who caused damages. Let's see what is course of employment. So an act done by the employee during the working hours for the purpose of carrying out their duty, even if it performed negligently, improperly, mistakenly, generally falls within the course of employment. Here employee may be negligent according to the provision. Even if he is negligently or else improperly or else mistakenly makes any wrong, then for that act also employer is liable to pay the compensation. Okay, let's analyze the question. Now see, in this case, it is a negligent act of the Ravi. While reversing the van, he hit the Kishore. Now Kishore was met with the damages. Now Kishore wants to claim the compensation against company. Now here, according to the rule of tortious liability, now company is liable to pay the compensation. Okay, let's see the conclusion of this question. Here the conclusion is SpeedX Delivery Services Limited should pay the compensation. See, SpeedX Delivery Services Limited should pay the compensation because it is vicariously liable for the Ravi's action. Here, employer is generally liable for the torts of their employees committed in the course of employment, even if the acts were negligent. So, according to this rule, here company should pay the compensation to Mr. Kishore. So, this is all about the law of tort. So, if you like the video and if you find it informative, please do share this with your friends who are giving the CS executive exams, and also I attach the PDFs which is in description that you can follow for your upcoming exams. In that PDF you can find revision sheet and also some important question and answers for the upcoming exams.